taking your time to tune in to today's webinar. So I'm Melissa Ngo. I'm a paralegal with Anthony Law Corporation. So this afternoon, I'll be sharing two different topics. So the first topic is on ABSD remission and temporary relief measures. And the second topic will be buying property under trust in Singapore. So without further ado, I'll begin with my first presentation. So first of all, what is ABSD? So ABSD is additional buyer's stamp duty. So as you know, when you purchase a property in Singapore, you are liable to pay buyer's stamp duty. But ABSD is only payable depending on the profile of the buyer. So what does it mean by profile of the buyer? So there are three different criteria or three different things to consider whether one will have to pay for ABSD or not. First of all, the buyer is either an individual or an entity. Secondly, the nationality of the buyer. Thirdly, the number of property the buyer currently owns. So this is what ABSD is about, and when would you have to pay for ABSD? So as you know, the government announced on 6th of May 2020, these temporary relief measures relating to the property sector. So these measures aim to help individuals who are affected by the sales of the housing market due to the ongoing pandemic, as well as the implementation of the circuit breaker measures. So this is what we will be covering today regarding ABSD remission and what are the current measures to help individuals. So let's begin. I will talk about ABSD remission. So what is ABSD remission? ABSD remission means that it relieves a taxpayer from paying tax. So it means that you are exempted to pay tax. So as you know, there are various transactions whereby party can apply for ABSD remission, but the one that governs under the measures, whereby the measures will help, is regarding ABSD remission for married couples. So it is very important for us to know what is married couple. Under the law, it defines that it has to be a Singapore married couple, which means either the husband or the wife must be a Singapore citizen. As long as one of them is a Singapore citizen, they are applicable for this ABSD remission. So what type of transaction will help married couple? So here, under ABSD remission for married couples, there are two scenarios. So our first scenario is the upfront remission for purchase of first residential property. So this is the first type. And secondly, the refund of ABSD paid on the purchase of the second residential property. So in the next few slides, I will explain further what are these scenarios and how it can help married couple in their ABSD remission. So this is the first scenario which I mentioned earlier. So it's whereby married couple jointly purchase their first residential property. So the rule states that full ABSD remission may be applicable to a married couple who purchases a residential property jointly. So there are obviously conditions to meet, and once the conditions are met, we can apply for ABSD remission instead of paying for ABSD. So I will explain the conditions first, then I will further elaborate on the rules. So what are the conditions? As you can see, the first condition, like I mentioned earlier, one of the spouse must be a Singapore citizen. So they will be deemed under Singaporean married couple. Secondly, which is very important, the property, their residential property, must be purchased under both names of the couple only. This means the property must be in the name of the husband and the wife and no one else. So it can't be the husband, the wife, and for example, the husband's mother. that will not fulfill the condition. It only can be in the name of the husband and the wife. And the last condition, both spouses must not own any residential property. So this purchase is their first house and they do not currently own any other property. So when would this rule apply? So as I mentioned earlier, ABSD is payable based on the nationality, the entity, as well as how many properties you own. So let's say if this married couple both do not own any property, by right, they don't have to pay for ABSD. But let's look at whereby a Singapore citizen and a foreigner, or a Singapore citizen and a PR, if they purchase a property, by right, they have to consider the PR's or the foreigner's profile. And if they follow that, there will be ABSD payable. But under this rule, ABSD remission for married couple, if they jointly purchase, they can apply for full ABSD remission. So they don't have to pay at all, and we will apply. But always remember, this is subject to IRAS approval. So I hope you understand this first scenario, which is straightforward, whereby married couple purchase their first residential property, and we can apply for full ABSD remission. So now, let's look at our second scenario, whereby married couple jointly purchase their second residential property. So means this is their second property. So let's look at the rule. Under the rule, it says that ABSD refund may be applicable to a married couple who purchases a second residential property jointly. So same as the first scenario, there are conditions to be met. But what is different in this second scenario is that the couples will have to pay ABSD on the second property first, and then we will apply for the refund after the sale of their first residential property. So in the first scenario, the couples do not need to pay for anything, and we will apply for the ABSD remission. But in the second scenario, the couples have to pay for the ABSD first, and once they sell off their first property, we will apply for the refund. So let's look at the conditions that are applicable. First, same like the previous one, it has to be one Singapore citizen spouse, so either the husband or the wife. And the property must be purchased under both the names of the couple, so same as just now as well, husband and wife's name only. And the third condition, the married couple did not own interest in more than one residential property when purchasing this second property. So this essentially means that they only have one existing property. If let's say they have two existing property, then this will not be applicable because they are purchasing their third residential property. So this first residential property under condition 4, it can either be co-owned, which means owned by the husband and the wife, or it can be separately owned. So it also applicable, let's say the first property is under the husband's own name only. Okay, and the critical condition here is that the first residential property must be sold within 6 months after the date of purchase of the second property for completed cases, or within 6 months after the issue date of the TOP, which is the temporary occupational permit, or the CSC for BUC. So this we categorize as the sale timeline. So when must they sell their first residential property in order to get a refund? So condition 6, like I said earlier, they have to pay for the ABSD first, and the last condition, they must apply for the refund within 6 months after the date of sale of the first residential property. So it is also very important that you apply for the refund within the timeline given. So this is the second scenario whereby married couple purchase their second residential property. And let's see how the temporary relief measures help this group of married couples. So let me explain further regarding the normal ABSD regime. So like I mentioned earlier, there is a sale timeline to meet in order to get the refund. So under the normal regime, without without the new measures, for couples to apply for the refund, they must sell their first residential property within 6 months. So within 6 months of either first one, the date of purchase or the exercise date of the second property, or let's say for BUC, within 6 months after the issue date of the TOP or CSC, whichever is earlier. So this is the current rules, whereby for married couple who wish to apply for an ABSD refund, they have to sell their first residential property within 6 months after the date of purchase of their second property or after the issue date of the TOP of the second property. So let us just absorb this first, and then now we will look at how the temporary relief measures help married couple. So bear in mind, they must sell within 6 months to be able to apply for the refund. So now let's move on. So as we mentioned earlier, the introduction of the temporary relief measures. So under these measures, which help the property sector, there are two important conditions to meet, okay? So the first condition, their second residential property was jointly purchased, means the husband and wife jointly purchased the second residential property on or before 1st of June 2020. So for this means that either the exercise date for completed matter or the SMP date has to be on or before 1st of June 2020. And the second condition, so as I mentioned earlier, the sale timeline. So this is where it comes to play. The original timeline or the latest date the couple must sell their first residential property falls on or after 1st of February 2020. Okay, this may seem a bit confusing, but I will give a few scenario examples to explain further. But for now, just make sure that you understand there are these two conditions. So first of all, the second residential property was purchased on or before 1st of June 2020, and the couple must sell this first residential property on or after 1st of February 2020 to meet the timeline. So if this couple meet both the condition above, which means they purchase before 1st of June 2020 and the timeline to sell is expired on or after 1st of February 2020, what the government says is that these couples are eligible for an additional 6 months extension, which means now the original 6 months and an additional 6 months for them to sell. So in total, this couple will have a total of 12 months to sell their first residential property in order for them to be eligible to apply for the refund. So I hope you understand these slides regarding the conditions, the first and second conditions. And if the couple meet both conditions, what they're entitled to is that they get an additional 6 months period to sell their property, and then they can apply for the refund subsequently. So now, as there are so many numbers, I will give a few examples on how this is applicable. So our first scenario for resale. So let's say a married couple, Singaporean married couple, Mr. and Mrs. Lee, they already own their first property, and now they jointly purchase their second property on 1st of November 2019. So 1st of November 2019 is their exercise date of the second property. So as I mentioned earlier, there are two conditions to meet. So let's see, the first condition, the exercise date of the second property is 1st of November 2019. And what does the first condition say? The purchase, it has to be on or before 1st of June. So this couple purchased it on 1st of November 2019, which is on or before 1st of June. So the first condition is met. So let's look at the second condition. Remember, I mentioned there is a sale timeline for the couple to sell their first property, and in order for them to meet the condition 2, they have to sell the first property within 6 months of the exercise date, which means 1st of November 2019, we plus 6 months. This gives us 1st of May 2020, which means the couple must sell their first property on or after 1st of February, and hereby this couple must sell by 1st of May 2020 to get the refund. So this means that the second condition is also met. So what does this mean? So hereby the married couple is eligible to the 6-month extension to sell their first residential property. And if they sell within this timeline, they can apply for a refund. So let's see. The original timeline is 1st of May. And now they have an additional 6 months to sell. So in total, they must sell by 1st of November 2020. Okay, so they have 12 months to sell. So as long as this couple can sell by 1st of November 2020, this one, if they can sell by then, they are eligible to apply for a ABSD refund. So I hope you understand these slides, whereby this couple meet both condition 1 and condition 2. And as long as you meet both conditions, you get an extension of 6 months from your timeline to sell. So in this scenario, the couples now have 12 months to sell. So let's see our second scenario. So second scenario is also a resale matter. So this Singaporean married couple, they previously owned the first property, and now they jointly purchased their second property on 28th of July 2019. So the exercise date is 28th of July 2019. So let's see the first condition. The first condition says you must purchase on or before 1st of June 2020. So 28th July 2019 is before 1st of June 2020. So the first condition is met. Okay, let's see the second condition. The timeline to sell the first property. So based on the exercise date, 28th of July plus 6 months gives us 28th of January 2020. So you see, the second condition states that you must sell your first property on or after 1st of February. As 28th of January is before 1st of February, this couple did not meet the second condition. So second condition is not met. So what this means that the couple is not eligible to the 6-month extension. So this means that the couple must sell the property by 28th of January 2020. So there is no extension for this couple. So it is very important for you to remember that even though you meet the first condition, if you don't meet the second condition, you are not eligible to the extension. So both conditions come hand in hand. So let's see our third scenario. So this is a case of BUC, whereby it's not completed yet, okay? So this Singaporean married couple, they previously owned the first property, and now they jointly purchased another property which is not completed, so a BUC case. So they purchased on 15th of May 20. So they purchased on, So they purchased on 15th of May 2017. So this is actually the SMP exercise date, okay? So they purchased on 15th of March 2017, and the TOP was issued on 3rd of December 2019. So let's see our first condition. As I mentioned, the first condition, the purchase has to be on or before, and the purchase here is the SMP date. So 15th of March 2017 is before 1st of June 2020. So the first condition, they meet. What about the second condition? the timeline to sell their first property. So previously, we talked about resell. So our timeline is 6 months from the exercise date. But this is a BUC case. So we base on the TOP date, which is 3rd of December 2019. So 3rd of December 2019 plus 6 months. So the couple must sell by 3rd of June 2020 in order to be eligible for the refund. So this means that 3rd of June is after 1st of February 2020. So the second condition also met. So first condition met, second condition met. So the couple is eligible for the 6-month extension. So now the couple has another 6 months from the original timeline. So this gives the couple up till 3rd of December 2020 to sell. So they have a total of 12 months. So I hope you remember for BUC cases, the second condition, the time of 6 months is after the TOP date and not the SMP exercise date. So this is the difference between the BUC as from the resale case earlier. But both cases, either BUC or resale, they must meet both the conditions. So our last scenario is also a BUC, whereby this couple purchased their second property on 1st of May 2020. Okay, so, but the TOP is estimated to be issued on 1st of April 2022. So let's see the first condition. So the SMP exercise date is on 1st of May 2020, which means that the purchase is on or before 1st of June 2020. So first condition, this couple meet. What about the second condition? The timeline to sell their first property. So remember, this is a BUC case, so we follow the TOP date. So the TOP date here is on 1st April 2022 plus 6 months. So this gives us 1st of October 2022, which is still on or after 1st of February 2020. So in this case, the second condition is also met. Okay, but the thing is that this is in the future in 2022. So as long as there are no amendments, there are no lifting or removal of the temporary relief measures, married couples will still be entitled to the 6-month extension, which means that in this case, the couple will actually have 6 extra months from the 1st of October 2022 to sell their first residential property. But we would like to just remind you that these measures, these temporary relief measures, they are in place to provide relief to SG married couples affected by the COVID-19 pandemic, as well as the circuit breakers measures. So as long as all these are still in place, yes, even in the future, this may be applicable. So we hope that you understand all the different scenarios and the timeline. And now I will summarize further for you to see when is the timeline that is applicable. So always bear in mind, this ABSD remission is only for Singapore married couple. So as long as the husband or the wife is a Singapore citizen, they are eligible for this ABSD remission. So let's look at resale matter first. Okay, completed residential property. So when is the earliest purchase date or the earliest exercise date of the second property for the couple to be eligible for this 6 months extension? So the earliest purchase date has to be on or after 1st of August 2019. So why do we say 1st of August 2019? So let's see. As long as if you purchase on or after 1st of August, your timeline to sell, which means your 6 months timeline to sell, will definitely be on or after 1st of February 2020. So let's just digest this first. The earliest purchase date for you to buy a resale property is 1st of August 2019, because if you plus 6 months, the sale timeline will be on or after 1st of February. And this will meet the second condition, whereby you must sell on or after 1st of February. So remember, the earliest purchase date is on or after 1st of August 2019. So this means that if a purchase is bought in July or June 2019, it will definitely not meet the second condition, even though it is purchased before 1st of June 2020. So remember this, the earliest purchase date is on or after 1st of August 2019. What about the latest purchase date, which means the latest exercise date of the second property? So this is very straightforward. As long as they purchase on or before 1st of June 2020, they will meet the first condition. So what does this mean? So this gives us the purchase period. So as long as the property is purchased between 1st of August 2019 to 1st of June 2020, the couple will be eligible for the 6 months extension. Remember, 1st August 2019 to 1st of June 2020. So this is the timeline for married couples to be eligible. So this is, remember, this is for resale. So now let's look at BUC cases. So I hope you understand this timeline and how it is applicable. So for BUC cases, which means not completed, similar, it has to be a Singapore married couple. So let's see, when is the earliest, so let's see, when is the purchase date or the SMP exercise date? As long as it is on or before 1st of June 2020, this is to meet the first condition, okay? So as long as the SMP exercise date or the purchase of the second property is on or before 1st of June 2020, they will meet the first condition. So let's see, when is the earliest TOP or CSC date? Okay, same like just now, remember, it's on or after 1st of August 2019. Why? If you plus 6 months, it will be on or after 1st of February 2020. So as long as the TOP date is on or after 1st of August 2019, you will meet the second condition, which is the original sale timeline is on or after 1st February 2020. But bear in mind, this is all as long as the temporary relief measures are not being lifted, are not being removed. This will be applicable. So I hope that this is clear for you to understand when is a timeline for you to be eligible to get the 6 months extension in order to apply for the ABSD refund. So now I will answer a few questions regarding this ABSD remission. Okay, so based on, I have a question here by Danny. So the question goes, what if both husband and wife separately own one other residential property? So as I mentioned earlier, the first residential property, it can be co-owned or separately owned. The couples are still eligible to apply as long as they sell within the time period. So it doesn't matter whether the first property is separately owned or co-owned. So I hope this answers your question, Danny. So is there any other further question on this ABSD remission for married couples? So let me answer this second question. So Singapore citizen and Singapore PR. So let's say the first matrimonial home, no ABSD. Yes, this falls under the first scenario, as I mentioned earlier, when the couple jointly purchase their first residential property and it has to be a Singapore married couple, there will be no ABSD because we can apply for ABSD remission. So the next question, how about US citizen? So remember, this ABSD remission is only applicable for married couple. So let's say if the US citizen purchase, it will be under different rules. So I just hope that today we are only covering regarding ABSD remission for married couples. But I understand that for US citizens, under the free trade agreement, there will be no ABSD payable. So let me answer the next question. So I'll just answer this question first. For a single Singapore citizen buyer bought resale property and can get ABSD remission and eligible for this too, sorry, this is not applicable for single purchaser. This is only applicable for married couples. So any other group of buyers, be it single or purchasing with siblings or parents, these are not applicable. These are only for married couple. So the next question by Cassandra, how about if client has industrial or commercial properties? In this case, is it still applicable? This is only applicable for married couple purchasing residential property. So this will not be applicable. So the second last question, okay? One party foreigner join them for second property applicable. Again, this is only applicable for married couple. So depending whether those parties are married couple or not. If they are not married couple, this is not applicable as well. So this is the last question. So by Mr. Faris, a Singapore citizen plus a foreigner can get ABSD refund for matrimonial. So depending whether is it their first property or their second property. So let's say if it's their second property, if they sell within the time period, they can apply for the refund. But if let's say if their first residential property, they can apply for ABSD remission. Remember, this is only for married couples. So I hope that all the questions are answered, and I will move on to the next topic for today. Okay. So now I will be talking about buying property under trust in Singapore. So this will be our second topic for today. So let's ask ourselves, what is a trust? So today I will be explaining what is a trust, who can be the trustee, who can be the beneficiary, and the procedures involved in buying property under trust in Singapore, as well as important things to take note. So without further ado, I'll begin with what is a trust. So what is a trust? Okay, simply put it is a legal arrangement which allows someone, and this someone is usually the trustee, to hold a property for the benefit of another person, which is the beneficiary. So what does this mean is that when buying property under a trustee usually holds the benefit on behalf of another person, which is the beneficiary. So I will explain this in further detail. So it is important for us to understand the different interests when you buy a property. So when you buy a property, there are legal interests as well as the beneficial interests. Okay, so let's see. When under normal circumstances, okay, so let's say an individual buys a property, these normal circumstances, Mr. A, let's say he buy a property, he will own the legal interest as well as the beneficial interest. So what does this legal interest or beneficial interest mean? Okay, I will explain. First of all, legal interest. Okay, let's see what is the legal interest. Just look at this diagram. The house and the title deed and the key. So these by right are the legal interest. Why do I say that? Because when you own the legal interest, you own the legal title, which means the property is under your name. So it's under the name of Mr. A. Okay, and you have control over it. You have the key to the property. You can sell the property. You can use it. You can possess it. You can even transfer it. These are all your legal interests. Okay, so this is what it means by legal interest. What about beneficial interest? Beneficial interest here. Look at this. Just think about the money as the beneficial interest. Why? Because you are entitled to all the rights or to the benefits of the property. So what are the benefits of owning a property? You have the benefit of staying in the house. Or for example, let's say if you sell the house, you get money, right? Those are all benefits from the property. Or for example, if you rent the house, the rental proceeds, these are all benefits. So usually when someone buy a house, they own the legal as well as the beneficial interest. So legal interest give you the legal rights, beneficial interest give you the beneficial rights. So I hope that it is clear now that when you think about legal interest, you think about the title deed, the control over the house. When you think about beneficial interest, think about the benefits. So which means the money, okay? So this is under normal scenario. When you buy a house, you own the legal as well as the beneficial interest. So what is the difference when you buy property on trust for a child? So usually the parent, the trustee, buys property on trust for the beneficiary, the child. So here we will see the parents do not own the legal interest and the beneficial interest. The parents only own the legal interest, but the child own the beneficial interest. You see? So this is where the differences comes in when you buy a property under trust for your child. So I will explain further how does it work out when the parents own the legal interest, but the child own the beneficial interest. So let's see this diagram. So we all understand legal interest, beneficial interest. So legal interest means you have the legal rights. Beneficial interest means you are entitled to all the benefits of the property. So when parents buy property on trust for the child, parents here, you see the parents, the trustee, they are the legal owner. So like I showed you earlier, the title deed and the keys. So this means that the property is purchased under the parents' name. So let's talk about Mr. Wong, okay? And Mrs. Wong. So this means that the house is purchased under both their names, Mr. and Mrs. Wong. So their names will reflect on the title deed and they have control over the property. But you see, they are only the title deed, right? The child, the beneficiary, is the beneficial owner. As I mentioned earlier, beneficial owner means the child get all the benefits. So you see, the parents only hold the property under their name. But whatever benefits, all the money or all the proceeds belong to the child. So this is the key difference when parents buy property on trust for the child. Because parents is only the legal owner, but whatever benefits, whatever proceeds, the sale proceeds, the rental income, it all belongs to the child, to the beneficiary. This means that the child's name, the beneficiary name, is not registered on the title deeds as well. So the parents actually, as a trustee, has a power and duties to the child. So we will explain further what are the power and what are the duties of the parents as a trustee. So I hope for now you understand that as a parents, they are the legal owner, and as a child, they are the beneficial owner, and as a trustee, their powers, their duties. So this is the general idea when parents buy property on trust. And with this, we will explain further. We will move on to our next slides. So now, who can be a trustee? So we already understand what is a trust. A trust is when the trustee holds the property for the beneficiary, okay? And we understand the difference between legal interest, which means you have the legal title, you have the right and control over the property, and beneficial interest, which means you can get all the benefits of the property. So now, who can be a trustee? Our first point, anyone who are not incapacitated from holding title to a property can be a trustee. This simply means that a trustee must be at least 21 years old and is of sound mind. So just remember, trustee can be anyone who are above 21 years old and they are of sound mind. Secondly, you may ask, how many trustees can I appoint? Under the Trustees Act, there are a maximum of 4 trustees that can be appointed to a trust. So anyone can be a trustee as long as they are 21 years old and of sound mind. And there are a maximum of 4 trustees that can be appointed. And always remember, the trustee should only deal or should only manage the property in accordance with their powers and their duties. We will explain further what are the example of powers and duties of a trustees, but usually the powers and the duties will be set out in the trust deed. Okay, so this is a general idea first, who can be a trustee. So remember, the trustee, they hold the legal interest. Okay. So next, we understand who can be a trustee. So let's see, who can be the beneficiary? Okay, our first point, generally, anyone can be the beneficiary of a trust. Actually, there are no age limit even on who can be the beneficiary. But let's see. Usually adults, as long as they are 21 years old and above. So adults here, which means above 21 years old, can hold the property in their own names. So this means that usually this type of arrangement, they are for minor beneficiaries. When we talk about minor, they are under the age of 21 years old. So why do we usually have trust arrangement for minor beneficiaries? So it's a little background for you to understand better, because as a child, if you are under the age of 21 years old, you have no legal capacity. Okay, so you see this child under 21 years old, they have no legal capacity, which means they cannot own a property using their own name. So what parents can do, let's say if parents wish to buy a property for their child, so we can create this trust deed whereby parents could buy a property by way of a trust. So this means that the child can beneficially, remember I mentioned earlier, the beneficial interest, the child can beneficially own the property. So child will always have a beneficial interest. Okay, so this means that when the child reaches the age of 21, so when the child is 21 years old, the child is already an adult, then the child can hold the property in his or her own name. So they have full legal ownership to the property. So this in general is who can be a beneficiary. Usually is for a minor under the age of 21 years old. So let's recap what we have understood so far. We've looked at what is a trust. We understand or we learn the difference between legal and beneficial interests. Then we have even covered who can be a trustee, who can be a beneficiary. So now the important part, how do we create a trust? So how is a trust formed? Usually it is formed by way of a trust deed or a declaration of trust. So this is a formal document. Like I mentioned earlier, it's a legal arrangement, okay? So in this trust deed or in this declaration of trust, it actually outlines all the duties and powers of the trustee. So let's see, this is a trust deed, right? So it will have the duties, the powers of a trustee. So what else is included in a trust deed? It will also include the particulars of the trustee. So the trustee's name, the beneficiary's name, and the trust property. So the address of the property, and it will explain the way how the trustee should manage the property on behalf for the beneficiary, the child. So once we prepare this trust deed, what are the formalities after the trust documents are prepared? So once we prepare, you need to stamp the trust document, and we need to register the trustee's interest. This means that we will lodge a purchases caveat. Remember, it is purchased in the name of the trustee, so that we will have to lodge a caveat to protect the interest of the trustee as well. So this is how a trust form, usually by way of a trust deed and or a declaration of trust. So I hope you understand now how do we actually create a trust. It is by a legal document called trust deed. So now we understood how is a trust form. Let's see the duties and the powers of the trustees, which are all included in the trust deed. So first of all, what are the powers of a trustee? So I will explain the first point. The default powers of a trustee, they are all governed by the Trustees Act. So in this Trustees Act, it will stipulate all the powers of a trustee, and it will all be applicable. Okay, so these are governed by the Trustees Act. So all the powers of a trustee are included in the Trustees Act, and they will apply unless we expressly excluded in the trust document. So this trust document, the trust deed, is very flexible. You can include the powers that you would wish to put in so that it will govern the trustee. So secondly, so that are just general rules on the powers of a trustees. Don't worry. Now, what are more important is that what the usual powers that we will include in a trust deed. So under the act, okay, the trustee is empowered to make any kind of investment with the trust assets as long as he obtains and considers proper advice and carry out periodic review. So actually, the power of a trustee is very broad. They can make any kind of investment, but make sure that he obtains and considers proper advice. So in addition to this, in addition to the Trustees Act, usually in our trust deed, what are the power that will include is such as the power to invest. So power to invest, as well as power to insure the property. So the property, so the power to insure the property, as well as that any income from the property can be used towards the education or towards the maintenance of the beneficiaries. And also, it may include powers to even sell the property. But remember, with all the powers, any benefits are for the child. So the trustee cannot benefit secretly from this. Whatever powers that they have is in order to manage the property for the benefits of the child or the beneficiary. So I hope you understand that what are the general powers. So just to simplify it, the example of the general powers are to invest, to insure the property, to use the income from the property towards the education of the child or towards the maintenance of the child, and it includes power to even sell the property. So these are the general powers of a trustee. So now, let's see, what are the duties of a trustee, okay? These are very important. Duties of a trustee. So what do we mean by duties of a trustee? First of all, the trustee owes a duty of care to the beneficiary. This means that the trustee is responsible to act in the best interest of the beneficiary, which means that the trustee must act fairly and justly. Remember that it has to be in the best interest of the beneficiary. So let's see the different duties of a trustee. First of all, let's see our first duty, to take reasonable care in making investment with trust assets. So this means that as a trustee, when they want to invest in any assets, right, they must use their proper judgment. If let's say they are not sure, they should at least seek advice, get proper advice before making any investment. So these are the duties of a trustee, to take reasonable care in making investment with trust assets, which means that trustee should not make any bad judgment as well. Secondly, so if the duties also include to act fairly between beneficiaries. So this is when there are few beneficiaries, the trustee should be fair to both and cannot act in the best interest of one party over another. Thirdly, to comply with the terms set out in the trust document. So as I mentioned earlier, in the trust document, which is the trust deed, there will be all the powers and duties set out. And as a trustee, they have a duty to actually comply with all the terms. So what do I mean by comply with the terms? For example, one of the terms in the trust deed can stipulate that the trustee must transfer the property to the beneficiary when the beneficiary turns 21 years old. So as a trustee, when the beneficiary reaches 21 years old, they should transfer the property to the beneficiary. So this is an example of the terms that is set out in the trust document, and the trustee must comply. So fourth duties, these are not specific duties. There can be many more duties, but these are the general duties of a trustee, which is also to provide information and accounts to the beneficiaries when requested. So as long as the beneficiary requests for a certain information or accounts, the trustee must be truthful and must give those information to the beneficiaries. And the last one, okay, this is an important duty, not to make a secret profit from the trust. So what is this? For example, the trustee cannot invest in a property and then receive a commission behind it. Remember, whatever benefits arise from the property is for the beneficiary, and the trustee is merely managing this property on behalf of the beneficiary. So I hope that this is clear to you on the various duties of a trustee. So, as we understood, what are the powers of a trustee? What are the duties of a trustee? So, what happens if the trustee actually breaches the trust? What does this mean? That the trustee did not act in a way that is authorized in the trust deed. Okay, so there are consequences when a trustee breaches the trust. So the first one, breach of fiduciary duty and duty of care. As I mentioned earlier, the trustee owes a duty to the beneficiary. So when the trustee actually breaches the duty, it means that the trustee fails in his or her duty. So this is what it means by breach of fiduciary duty. So when a trustee fails in his or her duty. So what happened? If a trustee fails to perform his powers under the trust, the beneficiary, okay, let me bring your attention to here. The beneficiary may bring a civil suit against the trustee for breach of duty. So you see, this gave the beneficiary an avenue to actually sue the trustee if the trustee did not carry out his or her duty properly. For example, the trustee did not act within the power or made a really poor or bad judgment in investment. So these are considered a breach of trust. So what happened if, let's say, the beneficiary actually sued the trustee? So let's see this point, okay? The beneficiary may claim for specific performance. Okay, what is specific performance? Remember I mentioned earlier, by the age of 21, the trustee is supposed to transfer the property to the beneficiary, but the trustee refused. The trustee said, I don't want to transfer to you. But this is a breach of the duty. So what the beneficiary can do is claim specific performance, which is to force the trustee to perform his duties under the trust. So your duty is to transfer the property and you must transfer. Or the beneficiary can claim for damages, so which is to cover any losses from the trustee due to the mismanagement of trust assets. So it is very important to note that trustee should carry out his or her duty in the best interest of the beneficiary. And if there is any breach of duty, these are the possible avenue for the beneficiary to actually sue the trustee. So this is one of the way. Secondly, it is also a crime for breaching the trust. So let's see. Under section 405 of the Penal Code, it says that when a trustee, so let me explain this in a few different sections. Firstly, when a trustee entrusted with a property, means that when a trustee is given a property or authorized to manage a property, so usually this is a trust property, right? The trustee is entrusted with a property. Dishonestly misappropriate or converts to his own use that property. So this is the second criteria. Dishonestly misappropriate or converts to his own use that property. What does this mean is that this means that when the trustee actually use the property for his own benefit. For example, any rental income, the trustee use it for himself or herself. So let's say the trustee now has debts. The trustee use the rental income to pay off his debts. These are dishonestly misappropriate or converts to his own use that property. And what if the trustee dishonestly uses or disposes of that property? So this means that if the trustee actually sell off the property for his own benefit, this amounts to a criminal breach of trust. What does criminal breach of trust means? Basically, it means misuse of property or misuse of funds. So what happens if the trustee actually misuse the property or misuse the funds from the property for his own benefit? So the trustee actually commits a criminal breach of trust, which means it is actually a crime, and he shall be punished with imprisonment, which may extend to 7 years or a fine or both. So if a trustee actually commits a crime of criminal breach of trust, which means he misused the funds or he misused the property, he can be punished with either 7 years of jail or a fine, or the trustee may be imprisoned for 7 years as well as a fine. So remember, it is a serious offense to misuse the trust property or misuse the funds for the trust property. So this should let you know that trustee's duty is only managing the property. Whatever benefits that come from the property is solely for the benefits of the beneficiary. So we understood the various powers and duties. We even went to see further what does it mean or what are the consequences when you breach those duties. So now let us go back to what are the procedure in creating or buying a property under trust. So let's see the first one, okay? So when parents purchase the property and execute a trust document declaring that they hold the property on trust for the child. So the usual procedure is that parents will come across a property that they're interested and they would wish to purchase this property for their child. So what they can do is that they can come to us, we can prepare a trust document, and in this trust document, the trust deed, we will declare that the parents holding the property as a trustee on trust for the child who are or who is the beneficiary. So this is the first procedure. So once they come, we prepare the trust document and they will sign the trust document. Secondly, the trust document, it must be stamped contemporaneously with the purchase contract, which means that the trust deed and the SMP or the exercise of option, it has to be stamped together hand in hand. So this is the second procedure. Thirdly, once we execute the trust deed and once we stamp both documents, the trust deed as well as the purchase contract, we will register the interest of the child, okay? So interest of the child must be registered. So remember earlier I mentioned we lodge a caveat for the trustee and we will also lodge a caveat on behalf of the child. So this will protect the interest of the child. So once we do that, the last step, this is the final step. So when the child turns 21 years old, the parents will transfer the property to the child. So this will be when the child reaches 21, then the parents will come back to us and execute a proper transfer, transferring the property from the trustee to the beneficiary. So by then, the child will hold the property in his or her own name. So these are the simple procedure and they are pretty standard. So it's usually the most important thing is to execute a trust deed and to stamp them, and we will lodge all the interest, and only finally at the age of 21 we transfer the property back to the child. So I hope this is quite straightforward and is understood on how do we actually carry out. So once we understood how do we actually carry out this procedure, we will go to the important things to note. So let's see the first one. The parents purchasing the property on trust for their child cannot, okay, remember, they can't use their CPF funds. So let's see here. The parents cannot use their CPF funds. Why? Because CPF funds can only be used for the purchase of your own property. So remember the first thing, if parents buy property on trust for their child, they can't use their CPF funds to finance the purchase of this property. Okay, so this is the first thing to note, no CPF funds. Secondly, the parents will not be able to obtain a loan. So you see, the parents can't get a loan to finance the purchase. So why can't the parents get a bank loan to finance the purchase? So let me explain further. This is quite important to understand. First of all, as we remember that although the parents hold the legal title, but who are the real owner? The real owner is actually the beneficiary. Okay, so what does this mean? That the real owner is actually the beneficiary, which means that in order to get a loan, the beneficiary should be the one to obtain the loan. But as I mentioned earlier, the beneficiary are usually under the age of 21 years old. So this means that the beneficiary can't enter into a mortgage document with the bank. So the beneficiary can't sign all the mortgage documents. That is why the parents cannot obtain a loan to finance the purchase. So this means that it has to be fully cash. So what about the third things to note? If let's say either the trustee, so let's say if the trustee is a HDB or EC owner, purchaser or essential occupier, as long as if both the trustee or one trustee, they are Singapore citizen, The rule is that you can acquire private and HDB, but you must fulfill your minimum occupation period before you acquire a private property. So let me just explain this again. If let's say the trustee is a Singapore citizen and currently owns a HDB, they have to fulfill the MOP before they can buy property, before they can buy a private property. So remember, you must actually fulfill your MOP period first. What about, let's say, if the trustee is not a Singapore citizen? So the trustee means both, let's say if parents, both father and mother are a Singapore PR. So the rule is that Singapore PR cannot own HDB and private. They can only own either one. So if let's say the trustee is a HDB or EC owner, purchaser, or essential occupier, they have to dispose the HDB and EC within 6 months of purchasing the private property. So remember, Singapore PR, so for Singapore PR, you can only own HDB or private property. Okay, this is the rule. So let's say if you own a private, you must sell off your HDB. So I hope that these are important things to remember. And another thing that I would like to remind is that, let's say when the child turns adult, so when the child is 21 years old and the property is transferred to the child. So this means that the child currently has one property, okay? And let's say if the child wishes to purchase a second property, that second property will be subject to additional buyer's stamp duty. So there will be ABSD payable on their second property. Same, like I mentioned earlier, remember this one, okay? The rule is that you can own HDB, then own private, but you cannot own private property, then choose to own a HDB. So let's say in this case, if the child already owns a private property and they wish to buy a HDB, that is not possible. So the child must sell off the private property, then purchase the HDB. So these are all important things to note. I'll summarize. First of all, parents cannot use CPF funds to purchase. Parents cannot get a bank loan, so it has to be fully cash. And let's say if the parents are Singapore citizen, they must fulfill the MOP period if they currently own a HDB or EC. And if the trustee are all Singapore PR, they cannot own a HDB as well as a private property. So these are all the important things to note. So now, let me explain regarding another issue that is quite important, bankruptcy issue, okay? So I will just explain first of all, there will be difficulty in selling, okay? Let's go at this point, the difficulty in selling point. So this is because of the Bankruptcy Act, okay? So if any gift transaction is made within 5 years, there will be implication, there will be potential, it will be potentially hard to find any buyers within the first 5 years. So we usually advise that if you buy a property under trust, you're essentially doing a gift transaction. It will be hard for you to sell the property within the first 5 years. So these are the implication of buying property under trust. So why is this so? Why is it hard to sell within the first 5 years? So now, let's go under Bankruptcy Act, okay? So under the Act, it actually provides that if any individual enters into a transaction at an undervalue or if he makes a gift, and when we talk about transaction at undervalue or if he makes a gift, this actually involves buying property under trust. So within the 5 years period, okay, for a 5-year period, if anything happens to the trustee, let's say if the trustee is declared bankrupt within 5 years, what happens is that the transaction is declared null and void, okay? So this means that if let's say the trustee actually declared bankrupt within 5 years, and within that 5 years, they entered into this transaction, they actually bought the property under a trust, this means that this transaction will be cancelled. So what happens if this transaction is cancelled? So this means that the bankruptcy official can actually get hold of this trust property. So the bankruptcy official can take this property and can sell it off to pay off the creditors. So this is important to note. If anything within the 5 years, if the trustee is actually declared bankrupt, the property will no longer belong to the beneficiary. It will be in the hand of the bankruptcy official and to pay off all the debts of the trustee. But if anything happens 5 years later, if let's say the trustee is bankrupt 7, 8 years after buying this property under a trust, there will be nothing happen. Okay? This means that the property is protected from the creditors and it will still be under the name of, it will still belong to the beneficiary. So that's why it is always important to note of this 5 years period that it will be difficult to sell the property and because of the Bankruptcy Act. So let's look at another implication of why do we actually carry out, or why do parents buy property under trust for their child. So as you can see the table here, the additional buyer's stamp duty table. So before this, remember our first talk, I mentioned when do you have to pay for ABSD, okay? So additional buyer's stamp duty, ABSD. So remember I mentioned there are 3 things. Okay, first of all is whether is it a individual or a company or entity. Secondly, the nationality of the buyer. And thirdly, the number of property owned. Okay, so you see the count of properties. So why do parents actually buy property under trust? This is because we have to understand first the ABSD rules. So based on the 3 things, the profile of the buyer. Okay, so let's see here. Let me bring your attention to this. When there are multiple purchases, the purchaser with a higher ABSD rate will apply. So under the ABSD rules, so under this rule, it says that when property is held on trust, let's say when parents buy a residential property to be held on trust for child, the property count will be included as a count for the beneficiary, which means that this additional property is now owned by the child and not the parents. So let's see how would this help in the purchase. So remember, when a parent or when the trustee purchase a property under trust for the beneficiary, this property will go to the profile of the beneficiary and not the profile of the trustee. Okay, so what does this mean? That let's say we understood this is just to summarize again. When we buy property under a trust for a beneficiary, the parents, which are the legal owners, purchase the property and they hold it for the benefit of the child. Okay, so the child will be the beneficial owner. So remember, stamp duty is still liable, but this is based on the profile of the beneficiary. So for the buyer stamp duty, you still have to pay. Okay, but what about ABSD? Since the child has no existing property, so this property is their first property, no ABSD is payable. So remember, it also depends on the nationality of the child. As long as the child is a Singapore citizen, no existing property, the rule is that no ABSD is payable. So this is how buying under trust for a child can help in stamp duty as well. So however, remember that when the child turns 21 years old, the property is under the name of the child already, and the child, if subsequently purchase a second property, that second property will be subjected to ABSD. So remember that, okay? So this is the general rule. So when parents purchase property and hold it for the benefit of the child, the stamp duty is based on the profile of the beneficiary. As long as the child has no existing property, there will be no ABSD payable. So I hope that today's topic on buying property under trust in Singapore has helped you to understand better on all the procedures, the rules, and what are the important things to note. And now I will just put this slide here. These are a list of our business development team. They are all known as our BDM. If you have any further queries regarding the ABSD remission on our first topic, or if you have any further queries on buying property under trust, feel free to get their names, jot down the numbers, and contact them. They will be able to assist any of your queries, and I will now proceed to answering a few